Facts. The facts which gave rise to the present controversy involve two marriages and two families who share a husband and father, whose death brought about the question of who may claim the proceeds of his death benefits. For one, owing to the relevant law's guidance as to how the proceeds of the death benefits in question may be distributed to the beneficiaries, this issue is theoretically knotted, as it invites the court to make the journey into the territory of a long-standing doctrinal debate over a matter that the new civil code is decidedly silent on: the share of a surviving spouse in the event that said spouse concurs with one legitimate child, or with legitimate children in the context of an intestate succession. For another, the foregoing debate, once settled by the court, inevitably bleeds into the reality of the lives of the subject's surviving families, if a manner that reveals what perhaps may be a discerned gap in the law. Faced with the uncommon question of who between the long-estranged legal spouse and the subsequent spouse by a bigamous marriage may claim rights to the compensation and benefits for a seafarer's death, the court finds, pursuant to the relevant POEA rules and their cross-reference to the rules on succession, that only the surviving legitimate spouse may receive the proceeds of the death benefits alongside the deceased spouse's children from both marriages. A straightforward recollection of the relevant facts which inform the court's disposition is called for. Pedrito G. Macalinao and Serena Negapatin Macalinao married on June 5, 1981, and they were blessed with one child, herein respondent Cindy Macalinao. However, only 4 years after they were married, Pedrito and Serena separated. In fact, on April 3, 1990, with his marriage to Serena subsisting, Pedrito entered into a marriage with Elenita, after which they lived together as husband and wife for 25 years, until Pedrito's death on June 26, 2015. Before his death, Pedrito worked as a seafarer employed by Excel Marine Company Limited/Fair Shipping Corporation. Since he died on board the vessel of Excel Marine and was a member of the Association of Marine Officers and Seafarers Union of the Philippines, his death benefits were determined to be in the amount of $93,057.88 or 4,506,309 pesos and 50-2 cents. Issues. 1. Who among the two wives is entitled to the death benefit of the deceased? 2. How to partition the proceeds of the death benefits. Held. In all, the courts remain tasked to reach the heart of the matter of each controversy which, in this case, simultaneously revealed both a gap in the law on death benefits where one was not readily apparent, and 2. The discerned presence of a harmonized reading of the apportionment of a surviving spouse vis-a-vis a legitimate child and illegitimate children, where one was not expressly codified in the black letter of the law. For the former, the court is bound to find that the benefits for the death of a seafarer cannot be awarded to a spouse with whom he has shared 25 years of his life, but whose union is illegal in the eyes of the law, and that said benefits instead belong to the legal spouse and the 3 children who survive him who, regardless of the marital circumstances they were born into, are unqualifiedly entitled to the benefit provided by law for their unquantifiable loss of a father. For the latter, the court takes the opportunity to clarify that the absence of a particular provision does not mean the death of related provisions that can light the path to a retrace of the steps back to the historical moorings of the rules, in order to find the way forward to an interpretation that meets the need of the peculiar facts of the case, the requirements of the linguistic canons of statutory construction, and overridingly, the intent of the law as embodied in its text. For while the court notes that this interpretation will radiate across other related rules with impacts that may outsize it, the court holds truer still that in the process of managing from the reality of each nuanced controversy, any honest and intelligent attempt at enlightening the law is worth the while if only to build a more complete and increasingly coherent body of jurisprudence. Accordingly, the instant petition is hereby partly granted. The decision dated August 29, 2019, and resolution dated November 25, 2019 of the First Division of the Court of Appeals in CAGR CV number 112739 are hereby affirmed with modification, in that the amount of $4,506,309.52 deposited under the name heirs of Pedrito G. Macalinao by Excel Marine Company, Limited, and fair shipping to the office of the Clerk of Court, Regional Trial Court, Muntinlupa City be released to Serena N. Macalinao, Cindy N. Macalinao, Kenneth V. Macalinao, and Crystal V. Macalinao. Upon the presentation of appropriate identification cards/papers and, subject to the proper legal fees, and distributed as follows. 1. 1/4 to Serena N. Macalinao, in the amount of 1,126,577 pesos and 38 centavos. 2. 1/2 to Cindy N. Macalinao, in the amount of 2,253,154 pesos and 76 centavos. 3. 1/8 to Kenneth V. Macalinao, in the amount of 563,288 pesos and 69 centavos, and 4. 1/8 to Crystal V. Macalinao, in the amount of 563,288 pesos and 69 centavos. So ordered.